Hello, hello. Shall we begin? Hello. Can you hear me? Good afternoon, everybody, ladies and gentlemen. On behalf of the Council of Europe, first of all, please give me a sign that if anybody's having any problems hearing me, everybody's okay? With the earphones, good. On behalf of the Council of Europe, I'd like to welcome you here to this open forum we're organizing on the internet, terrorism and human rights, preventing misuse of the internet for terrorist purposes. It's a pleasure to see a full room today, this afternoon. I will start without much further ado. I have on our list of speakers, the opening of this open forum was supposed to have been delivered by our Director General for Human Rights and the Rule of Law. Unfortunately, Mr. Philippe Boya, our Director General, is currently engaged in a meeting with the Azerbaijani authorities. He sends his sincerest apologies for not being able to be here right now. He will try and join us as soon as possible, so I will deliver his message on his behalf, if you will allow this kind of swap. And then we will proceed to our speakers after this. So, on behalf of Mr. Boya and the Council of Europe, I welcome you to this open forum. It is a pleasure to see so many of you here, still walking in. Allow me to make some general observations in introduction. We can say that the internet has revolutionized the way we work and interact with each other. And the internet has made it possible for millions of people to have a voice in this world. Sadly, the internet also comes with a darker side. Due to its global reach, the internet has made it possible for criminals and terrorists to operate across borders with relative impunity, and it has made it much more difficult for law enforcement to identify and prosecute the persons behind crimes committed through or on the internet. A major threat to society stemming from the internet comes from its abuse by individual terrorists and terrorist organizations to disseminate their messages of hate, of violence, and of violence to a worldwide public with a view to radicalizing potential followers and spreading fear. Internet has in fact been labeled to be one of the greatest incubators for terrorism, together with prisons, for example. In addition, the internet has proven to be a communication tool for terrorists, as it is for ordinary law-abiding citizens, making it possible to pass vital information instantly around the world. There is also a constantly growing risk that terrorists may use the internet as a weapon to launch cyber attacks on critical digital infrastructure. We know that it can be done, and the consequences of such an attack on digital infrastructure of, for example, a nuclear facility can prove to be even more fatal than the terrorist attacks we have unfortunately experienced in the past. The organization I represent, and my colleagues here on this panel, is dedicated to the protection of and promotion of human rights, democracy, and the rule of law. As an intergovernmental regional organization, we have been active in facilitating our member states' endeavors in protecting their citizens against terrorism since the 1970s. This means we have 4 decades of experience in how to combat terrorism while, and this is crucial, fully respecting fundamental human rights and the principle of the rule of law. In our approach, what takes place online should be governed by the same standards that we apply in the offline world. Above all, we should not, in the name of freedom of expression, tolerate that the internet is abused to promote and undermine the very values for which democratic societies stand and which human rights are intended to protect. States have a positive obligation to protect their citizens against crime and terrorism. They must therefore take all measures to do so, given that these measures are provided by law, pursuing a legitimate aim, and necessary in a democratic society. And that does mean fully respecting the principle of proportionality. These principles clearly also apply to fighting the use of the internet for terrorist purposes, cyber terrorism as you may call it. The Council of Europe has developed standards, tools and mechanisms to meet this objective of protecting people against crime and terrorism, while at the same time protecting their rights while taking measures against these threats. These tools include the Convention on the Prevention of Terrorism, which to my right here, Mrs. Gertrude Kabelka will elaborate in greater detail, and the Budapest Convention on Cybercrime, which Mr. Alexander Zeger and to a certain extent Mr. Zahil Jamid will also go into greater detail about. Both these treaties combined allow countries to cooperate with each other and to pursue a well-balanced, proportionate response to the terrorist use of the internet. I underline that both treaties are open to third countries who may wish to join them. The Council of Europe Convention on the Prevention of Terrorism of 2005, which is our main legal tool in fighting terrorism, aims at preventing terrorism, including by ensuring that recruitment of and providing training for terrorists are established as criminal offenses. This is particularly important in the context of the internet. We're here at the Internet Governance Forum, which plays such an important role in the spread of terrorist messages and the radicalization and training of potential terrorists. Another very important legal instrument of the Council of Europe is the Convention on Laundering, Search, Seizure and Confiscation of the Proceeds from Crime and the Financing of Terrorism. It's a long name, from 2005 also. This convention aims at facilitating cooperation between state parties on tracking, seizure and confiscation of financial means intended for terrorist purposes. In this respect, the internet plays an important role because of the electronic banking systems can be used for transfer of money between accounts at both national and international levels, and the laundering of proceeds from the internet fraud with credit cards and other things, which may be a significant income generator for terrorist organizations. Finally, the European Convention on Human Rights is a keystone in our work. The European Court of Human Rights has, over the years of its operation, developed a well-established case law on the compatibility of measures taken by member states to protect their populations against terror attacks with their obligations under the European Convention on Human Rights. Through the case law of this court, member states are provided with important and essential guidance on how best to fight terrorism while respecting these fundamental human rights. This guidance, again, applies online just as much as it does offline. In addition, the Committee of Ministers of the Council of Europe adopted a set of guidelines on human rights and the fight against terrorism, which reflected this case law of the European Court of Human Rights in 2002 already. To sum up, no state should make use of the global fight against terrorism as a pretext for imposing any limitations on legitimate political discourse on the internet or in any other type of the media. One can never equate political dissent with terrorism, and the measures called for when suppressing terrorism can never be deemed legitimate if the purpose of the state is to silence political opposition. Let me end by saying that we should make use of the internet to counter the messages of hate and to demask the terrorists as the common criminals that they are. We should make use of the internet to promote human rights and democracy for all. Thank you for your attention, and I shall now pass the floor to Mr. Zahid Jamil, who is a barrister at law at the firm of Jamil and Jamil in Karachi, Pakistan, who will further provide us with a practitioner's perspective on this issue. Thank you, Jamil.
Thank you, Anna. Thank you for this opportunity. I'm not an expert on the Council of Europe Convention on Terrorism, but I have had some experience dealing with some of the money laundering issues that you discussed related to terrorism, and also dealing with certain cases that were actual, sort of caused death and all sorts of other concerns in Pakistan related to terrorism. Before we start, I think I'd like to something sort of came to me, and I'd like to mention this. In Budapest a few weeks ago, we were talking about with the youth, how to communicate, what is freedom of speech, etc. And there were these, two opposing views. Either you should just say whatever you want, have complete freedom of expression, which included you saying anything even if you were a terrorist, or if you loved Hitler. And there was another view which said, no, no, we need to take measures, and we need to weed out these different messages and block them or take them down. And I think there was a point I made, and I think that worked with some of the youth. In fact, I said, look, the idea is not to block things, because if you have messages of hate, for instance, and I gave the example of saying, I love Hitler. That's a terrible thing to say, especially in a European audience, even otherwise. And that message is going to be taken down. It doesn't really help in explaining to the youth what is wrong with that message. And what you need is to educate and to have the ability to be able to respond to these things. Now, how would you have a response to messages or acts of that nature? So, coming from my part of the world, if you see an extremist view on the internet, over Twitter, over a YouTube video, your response needs to be on the internet so that you can respond to it. And if there's a proper response, that will generate the interest or disinterest that others may have in it. But if the actual source piece information disappears, there's nothing to respond to. The arguments against that hate speech don't exist. And so that doesn't, I think, help. And what happens is you drive all that hate speech into closed networks, into the underground, and then they get the ability to basically say whatever they want to say. And there, the rest of the population is unable to counter it. So the counter-narrative, which is, I think, an important element in any sort of a counterterrorism strategy, is lost if you do that. It's better to name and shame. It's better to have that information there and then to really work at that. And I think the Council of Europe is doing some work on trying to teach bloggers, et cetera, to sort of, be responsive and take action. So I think, just wanted to make that one point. Now, from Pakistan's perspective, I really don't have to do a sales pitch to explain why terrorism is an issue. I think everybody in the room kind of knows that. In the kind of cases we have seen, I'll mention a couple, not too many. There was the case of Daniel Pearl. This is really some time ago. And I think it was one of the first cases that our country dealt with in its justice system where there was electronic evidence. Now, this was before I drafted the electronic transaction legislation for the country so that everything was acceptable, etc., under UNCITRAL model law. And it was pre that. And at that time, the judge was confused. And he actually sort of said, look, I have this evidence of logs and traffic data that has been obtained from the ISP, because that is what links the email that led to such a Daniel Pearl actually then going and meeting these people and then being taken hostage. And I believe as a convention, hostage taking is actually one of the terrorism acts as well. And what am I supposed to do with this? This is electronic evidence. It's not paper. What do I do with this? And you had to make the argument, and there were certain provisions under UK that the British had left us with in our Criminal Procedure and Evidence Act, which allowed us to bring it in. But it just shows you how this, cyberspace was used, in fact, partially, as there was evidence available also in cyberspace, that led to the conviction eventually in that particular case. But very easily, it could have been excluded. And cooperation between industry, between law enforcement, in order to get that data out, get that evidence disclosed to the court, helped in making sure that case came to some fruition. In 2000, before 2001, there was a legislation, and this is not because of 9/11. This is pre 9/11. We had a Terrorism Act which had a provision related to tribunals, and they had been given extensive powers. There was even a provision that said that you could, have a confession taken in front of a certain senior officer. And the Supreme Court heard a challenge on human rights issues and civil liberties and said, absolutely not. The only person you can make a confession in front of is going to be a judge or a magistrate. You cannot make confessions in front of even a police officer, no matter what rank he is at. And so we're going to strike down this legislation. And there was a whole swath of things that in that legislation was struck down. Now, what did that mean to that investigation? What did that mean to that prosecution? Those guys went free. And so the point I want to sort of drive home here is that they are not civil liberties and freedom of expression and all those protections and safeguards that ought to be in any legislation related to terrorism are not separate from, opposing, or conflicting with any terrorism legislation or provisions for terrorism, because they are needed. If you don't do your investigation and prosecution correctly, you will find that the investigation and prosecution will fail at some stage, especially in Europe. If it goes to the human rights court, it's going to fail. So it is in the interest of the investigation, it is in the interest of the law enforcement, it is in the interest of catching the terrorists that the civil liberties are protected. Otherwise, you're going to have two options. One, you just go completely outside the realm of the criminal justice system, and then guess what? That doesn't really solve the terrorist problem. That gives them no justification. Or you stay within that system and you actually try and defeat these people. So legal frameworks and legislation and even international conventions in that regard, which have balanced civil liberties included in them, are extremely important. So I'll give you an example of imbalances that we see in certain countries like mine. We come from the same region, India, Pakistan, others. We tend to be sort of confused about where the civil liberty balance needs to lie. For instance, as I said, a confession made to a police officer of a high rank was not admissible, but there is no provision for cautioning when the person is arrested. In fact, there is no provision that a lawyer should be present with you. In fact, he's excluded. Anybody who wants to be with that person, so you get out of the room. You have no business here. And if you were the subject of a prosecution or an investigation, you are in fact told on pain of being prosecuted that if you don't come here and make a statement under something called Notice of 160 and a statement in 161, which cannot be used as a confession, but at least it's a statement, and cooperate with us, you will be liable. These are the sort of things where there's an imbalance in certain developing countries where there needs to be the protection of civil liberties, there isn't, but there may be a disproportionate. So sometimes the weak governance frameworks in those countries don't work. And so you don't, like in my country, get convictions because you're completely imbalanced about what it is that you should actually be doing in this area for civil liberties. And you don't get the convictions, you protect the civil liberties as well, and you're not getting anywhere really. So what's the answer? The answer is that needs to be international best practices such as conventions and human rights standards that need to be brought into those countries to say you can't just use terrorism as an excuse to do abuse on the one hand. You need to make sure that those legislations have balanced human rights provisions in them. So let's take an example of the ones I've looked at. And as I said, I'm not an expert on the convention. But you have an actual specific provision under Article 12 of the Convention on Terrorism, which says that you must safeguard human rights, freedom of expression, freedom of association, and freedom of religion, and comply with the ICCPR, which I mean, that's a general principle. Now, any country that doesn't comply with that will actually be in breach of the convention they were party. And so that's the sort of thing you need internationally to convince many countries that, look, not only must you fight terrorism and cooperate to do that, but you've also got to comply with these standards. And that's why I think we see an imbalance all over the world. You may have certain provisions in the US and the UK, but you may not have in countries like mine. And there's another provision. If somebody finds information in my country which relates to terrorism, they are unable to share it. Because they say, well, under what legal provision will I send this to the US or the UK, etc., unless they ask me? And so what the convention provides is the possibility of spontaneous information. If you get something, you can share it. That concept doesn't exist in many developing countries which are hit by terrorism. So in any case, I want to end with this. The most important thing we found was that in cases like the 9/11 incident and then Faisal Shahzad in New York, etc., it is impossible to fight the terrorist threat unless you have cooperation within law enforcement internationally. And the only way you're going to make that happen if you want to get it binding is to have international, whether you have voluntary schemes, you have binding conventions, whatever you have, being in place, number one. But at the same time, also making sure that human rights are protected. And that's all I have. I know I'm over my time, but thank you.
Thank you very much, Zahid, for this really interesting and relevant intervention on the challenges that can be faced and are faced, I believe, by a large number of countries affected by terrorism, especially emphasizing the point on the need to balance civil liberties and security concerns. Now, you've talked about binding instruments, international instruments, so on this note, I will be happy to pass you on to Mrs. Geertruide-Kabelke, who is the Council of Europe long-standing expert on the Prevention Convention, the Convention on Prevention of Terrorism. She was at the forefront of the brainstorming, drafting, and many other events that we've lived through with this instrument and the terrorism legislation, standard setting, Council of Europe in particular. Mrs. Kabelke, you have the floor. Thank you.
Is this on? Yes. Well, thank you, Anna. Am I heard? I can't. Okay, all right. Well then, better now?
Yes.
All right. Well, I think it's always a bit difficult to speak in more general terms about legal aspects after having heard the very lively presentation of a real practitioner, but I'm grateful that we started that way, I must say that. However, I have to call on your lenience. I have to come back to, well, more general remarks and to present to you a bit you know, the things the Council of Europe is doing in the field. Now, quite a few things have already been said by Monsieur Boyard, or have been read out by Anna from his text. It was a slight overview of what's on the table from the side of the Council of Europe, and I should like, if the time permits, to go into some more detail. It will not be a lot of detail. 10 minutes are not too much for talking about conventions. But anyway, now the Council of Europe, as already has been said, is doing a lot since the 70s in the field of combating terrorism. And we must say that the more modern instruments, of course, are drafted in a way that they cover and include also internet abuse for terrorist purposes, and that's what's relevant for us here. But talking about the fight against terrorism, it's always important to have a look also at tools and methods for preventing such misuse, as well as at the ever-present necessity to strike a balance between the fight against terrorist crime on the one hand and the observation of the human rights guarantees on the other hand. In the latter respect, of course, we must find ways and means to ensure the protection of freedom of expression on the internet despite the ongoing fight against terrorism. Now, let me say a few words. Well, I'd like to tackle a few points, prevention and human rights issues, and if you allow me, I'll start with the prevention. In this area, as has already been mentioned, the Council of Europe has created an important legal tool, and that's the Council of Europe Convention on the Prevention of Terrorism, open for signature in 2005 and in force since June 2007. Currently, 29 countries have ratified it, whereas 15 further countries have signed the convention. All of them are, to date, member states of the Council of Europe, but I should like to reiterate what already had been said as well, that this convention, like many others of the Council of Europe, is open to the accession by non-member states as well. As a matter of fact, it has been drafted in a way that we thought it might turn into a kind of globally useful instrument, in particular since it's covering or filling a real gap or lacuna in international law and praxis, still doing that as a unique instrument in that field. Well, I don't want to sell it too much to you, the convention, because it has been mentioned how closely I am linked to the text. Well, according to Article 2 of the convention, it's the purpose of this instrument, and I quote, to enhance the efforts of states parties in preventing terrorism and its negative effects on the full enjoyment of human rights, in particular the right to life, both by measures to be taken at national level and through international cooperation. So even in the preamble, we start with covering the human rights aspect as well. I'll come back to that later. But we cover both aspects, the human rights of victims or potential victims and those of perpetrators, fair trial and so on and so forth. Now, the Convention purports to achieve this objective on the one hand by establishing as criminal offenses certain acts that may lead to the commission of terrorist offenses, and on the other hand by reinforcing cooperation on prevention both internally, that means on domestic level, by defining national prevention policies and international. I'll come back to that in an instant. First, however, I must briefly introduce those articles to you which deal with preventive measures explicitly. I'll start with the core provisions of the Convention, namely the penalization obligations of Article 5 through 7. They define 3 new offenses which the parties are bound to implement in their domestic criminal law. These offenses are acts committed in a stage of preparation. They refer only to the possible perpetration of concrete terrorist crimes, possible perpetration meaning that it is irrelevant for an offense under this new convention whether or not a real terrorist offense will be committed afterwards. 2 of these offenses are rather self-explanatory with their title, and they are recruitment for terrorism and training for terrorism. I'm not going into details on them, but I'll do that very well on Article 5, which defines public provocation to commit a terrorist offense as, and I quote, the distribution or otherwise making available of a message to the public with the intent to incite the commission of a terrorist offense, where such conduct, whether or not directly advocating terrorist offenses, causes a danger that one or more such offenses may be committed. The relevance of this provision for Internet activities is obvious, I think. The provision on provocation aims, inter alia, at avoiding particular objectives the perpetrators have in mind, namely such as recruiting or the strengthening of tensions that might contribute to the commission of terrorist offenses, the dissemination of hate speeches or hate messages, and the promotion of ideologies favorable to terrorism, while paying particular attention to the case law of the European Court of Human Rights. In addition to the introduction of new offenses, the preventive character of the Convention is underlined by other provisions as well, such as in particular Article 3 on national prevention policies and Article 4, which creates an obligation for international cooperation on prevention. Both provisions are applicable for the Internet world as well. One more remark in the context of this forum here. Even back in 2004 and 2005, when the Prevention Convention was elaborated, the drafters were aware of the impact any abuse of the Internet could exert on the initiation and perpetration of terrorist crime. With the wording of Article 5 concerning the, and I quote again, distribution or otherwise making available of a message to the public, unquote, the use of Internet tools for such activity is definitely encompassed. For this reason, to date, no need has been seen to envisage further tools, such as, for instance, another protocol to the Cybercrime Convention in order to cover the offenses penalized in accordance with the Prevention Convention. Now, I have to skip remarks about other convention of the Council of Europe. There is a dense network of treaty law, you can believe that, and you find it in the internet. But in addition to treaties, quite a number of non-binding, so-called soft law instruments have been adopted within the Council of Europe in respect of terrorism. These are resolutions or recommendations of the Committee of Ministers or the Parliamentary Assembly of the Council. 2 of them are of particular significance in our context, and I want to mention them. In the first place, those are the guidelines on human rights and the fight against terrorism, adopted by the Committee of Ministers in 2002. Based on the case law of the Court, they are a clear statement of Council of Europe standards in this field, thus having paramount relevance for the implementation of other legal instruments, such as, for instance, the Prevention Convention. The guidelines reaffirm the obligation of states to protect everyone against terrorism and reiterate the need to avoid arbitrariness. The framework set out in this instrument concerns in particular the collecting and processing of personal data and measures which interfere with privacy. The guidelines, I'm stopping at this. This document was later supplemented by guidelines on protection of victims of terrorist acts adopted in 2005. Now, of course, I've already touched human rights safeguards. Of course, I could tell much more about that. There are very interesting decisions of the European Court of Human Rights, in particular lately, the famous Leroy case, which the first time linked the human rights guarantees of Article 10, paragraph 2 of the Convention, also with victim protection, and the principles of the Prevention Convention. So much for that. If you have questions to that as well, I could tell you, of course, in the case, in the course of our discussion, and I hope we will have a lively discussion and you will have a lot of questions. Right now, I think my time has expired, as it's usual in such cases, and I thank you for your attention.
Thank you very much, Ms. Kabelke, for this very, given the time limitations, I think very coherent and very interesting introduction into the instrument that is the Prevention Convention of the Council of Europe. Now, for the sake of time, and as you know, this kind of forum, we have so many experts such as Mr. Jamil here who are engaged in many things. For the sake of being aware of time, I would like to open the floor now to questions to Mr. Jamil in particular on his intervention or anything related to this topic from practitioner point of view. If you have questions for Mrs. Kabelke at the same time, we can take those. We will then proceed with the presentations, but just being aware that Mr. Jamil will not be able to stay for the full duration of the forum, I would like to now open the floor to any questions you may have had. If I may ask you to just very briefly introduce yourself so we know.
Hello,
roughly who you are.
my name is David Leonardo from Navanti Group in the US. First of all, I want to say I agreed very much with Hassan about making sure that you don't block sort of terrorist pages on the internet, because, I mean, as people who work on counterterrorism, these pages are the greatest resource people have on tracking and following and just finding out what people are doing and what they're saying and the kind of narratives they're putting out. But on that, I wanted to ask about the punishments on distribution of message to the public to commit a terrorist act. For example, if someone had a page on Facebook to say to bomb something, but then someone were to share that, I mean, would that fall within that provision? Thank you.
Well, okay, thank you for that question, which is very relevant, of course. Now, my answer has to be the following. We cannot give a general answer to what falls under this provision and not, because it must be adjudicated in every single practical case that goes to court. First, of course, we need the necessary tools to find those messages, but once you have found them, then you just need to get these cases to court, and then it will be up to the courts to decide on this. Fortunately, I do not yet have any survey of national court decisions on that, I must say. There was one human rights court's decision which included the Prevention Convention, but not dealing with your question. So, as a matter of fact, it's a hot potato, but I must forward it to the judges of the national courts when you've got a case. I would say, personally, what you said, I would, say it's covered by the provision. That's my personal view, but I'm not the judge sitting on the case. Thank you.
I cannot give you an answer. Sorry, let me just take this off. I can't give you an answer from the convention's point of view. As I said, I'm not an expert on that. I can try and give you an answer from maybe my national legislation. And I just drafted the cybercrime legislation in my country. We were very conscious of human rights issues because we had advocated against the previous draft of the legislation. We didn't like it because of human rights issues. I think when a person actually posts a message with an intent, I think that is the key. And is it an intent to incite? Because messages are about inciting. That is the main thing. You're distributing a message. You're trying to sort of evoke a certain amount of reaction. Now, if somebody basically puts it on his Facebook because he wants people to see it, As a Facebook user, I would say, what was the intent? Did he want likes? Did he put a comment next to it? Was he trying to say this is ridiculous? That would give you some kind of context. The response you'd get from maybe civil society or somebody else would be, hold on a second, but that's like, shoot first, ask questions later, because that guy's going to get arrested, he's going to be put into jail, you're going to go through a trial, what's going to happen? And that can happen in many cases where intent is the issue. The answer to that, in my view, and I come from a developing country, and whatever we've tried to do there is, we found that procedures or procedural safeguards in court make a difference. Whether the person can get bail easily, whether there's an independent judiciary, what are the grounds on which they are able to actually see if the case can be dismissed early. I'll give you a simple example. In my country, you get arrested for anything, you can get out of bail. This is where the imbalance is. You can get bail easily, but what you can get is your case finished for the next 10 years. Now, there's something wrong with that. Maybe you want to be, not get bail in certain circumstances, but you want the case to come to an end. So I think if having procedural safeguards are extremely important when it comes to a case of this nature, because it's difficult, as was just mentioned. It comes to at the end of it, the judge has to decide. So the procedural safeguards are the answer where intention and things are a concern in those cases. I hope that, from my perspective at least, that answers something. Thanks.
Maybe I should add something. Would you like to quickly add a comment? Sure.
Sorry, I'd just like to add one sentence, because that was a very relevant remark about procedural safeguards. I did not have sufficient time to say that in our convention we do have an article, a full article on such safeguards. It has been mentioned, that's what you said, Article 12, that goes along with the penalization provisions, and that of course makes sure that in all of such cases the full spectrum of human rights protection afforded by the European Convention, but also the International Covenant, for instance, where applicable, has to be maintained. So that's a very important addition to what I've said before. Thank you.
Thank you, Mrs. Kabelka. We have a gentleman over here.
Hello, my name is Siim Tuisk. I'm from ISOC Estonia, and my location also plays a role in my question. In 2007, we had a sort of cyber war between the Estonian state websites and the Russians. It originated, the DDoS attack originated in Russia, sorry. And why this is important at the moment is that with the recent, for example, the cases with Anonymous and all the different DDoS attacks towards certain websites, my question is, and I don't know whether or not there is somebody that would like to answer that, are there legitimate reasons that one could imagine that if the state citizens, without any botnets, without any sort of additional criminality, would want to do a sort of cyber sit-in against their own government or their own institutions, not from outside, their own, like citizens against their sort of thing, would it be any case that there wouldn't be considered terrorist use, as with DDoSing generally it's not really accepted on generally in international forums, it is not really questioned that it could be a legitimate, that there could be a legitimate use. So if anybody wants to answer that, this would be my question. Is there a possible way to use DDoS by the citizens against their own institutions or companies that might be excluded from the terrorist use?
Zahid, if you would like to.
I'm sure there are other comments to this as well. When we were drafting, actually, this is interesting because this is more about cyber terrorism and DDoS and less terrorism per se. And when we were drafting this legislation back home, the issue came up that, and a couple of things that we had to sort of struggle with. So let me just quickly get them out. We found that we're looking at legislation, it's very important to try and distinguish between an offense that deals with intent, something that you've done with intent, and something you could have done it recklessly. And we found that in many places they were sort of combined when you used to start, so we had to separate them. Because otherwise what ended up happening was that you may have done something which was not necessarily a terrorist intent, but you got the same offense because there was nothing else for them to charge you under. So we said, no, they have to keep two different types so that we can distinguish between the different types of actions that have been taken. The second was we included two words. One was serious, and the second was harm. Because you have to, if it's what kind of impact is it having, whatever you're doing? And that's not even cyberterrorism yet. And the kind of disruption that you're causing. And so those are the sort of things where you would, when you're drafting any sort of provision in national law, at least I'm not sure about how we do it in a convention, you need to have those safeguards in there. I'm not talking about procedural ones, I'm talking about the ones in legislation where you would make sure that you are able to carve out actions that are taken like the one you mentioned, and they don't suddenly fall in automatically by default because you have nothing else to charge them with under cyberterrorism legislation. But that's just a parochial national response.
Thank you very much, Zahid. If Ms. Moritz, you will excuse me, I will just quickly take a question in the form of a small intervention potentially from Dr. Ian Brown, who is the Associate Director at Oxford University Cybersecurity Centre, and I will get back to your question.
To follow up on that last point, but also the opening remarks, I think what Zahil was just saying is really critical here. Of course, necessity and proportionality is an absolutely fundamental part of the European Convention on Human Rights. And precisely defining these terms, like cyber terrorism, cyber warfare, rather than throwing them around as, as disruptive as what happened in Estonia might have been, that there isn't evidence linking it to the Russian state. I would say shutting down access to some government websites, some bank websites, some newspaper websites, certainly inconvenient for Estonian citizens. Certainly not a good thing, I'm not trying to justify it. But to say that is an act of terrorism, I think is going way too far. I thought some of the opening remarks, Anna, I know they weren't your remarks, really fell prey to this. Talking about nuclear power stations being attacked in cyber terrorism incidents is just hysterical. Literally. I say that as a computer security expert, computer scientist. Nuclear power stations should not be accessible through the public internet, full stop. If they are, that is a catastrophic engineering and design failure by the people running them.
Thank you. I believe we have another question here on the right.
Thank you so much. My name is Julia Mornes. Good afternoon. From Together Against Cybercrime, I don't have a legal question actually. As we are in the format of multi-stakeholder meeting, which is the IGF, I have a global question to all participants, and he just was talking about youth, and my question is, what is the role of the civil society, or from your point of view, in this process of the prevention of the use of internet for terrorist purposes? I would be interested to know about. Thank you.
This is you turn to me, right? May you please...
Generally, to all speakers.
Okay.
I was just,
may you just please... I'm not so sure I got the gist of what you wanted to know. Can you repeat the core of your question?
I was just interested about to know your opinion about the role and the importance of the civil society in this process of the prevention of the use of internet used for terrorist purposes. Because we just discussed about, he just was talking about youth and awareness raising. And I do have other questions afterwards, but a general question as we are here in IGF. Thank you.
Well, thank you. To tell you the truth, I'm very grateful for your question, because now I may say something for which I didn't have time enough before. Because we do indeed, in the Prevention Convention, we even have provisions that have to do with civil society, because there is this Article 3 on national prevention policies, which I mentioned. Of course, now the obligation is on states, but states have to do a lot for awareness raising, education, cultural development, including civil society, including NGOs, and so on and so forth, in an overall strategy, prevention strategy. So we do have exactly that in the convention as an obligation for states to do it, but then of course civil society must jump in, must come in and participate. But it's covered in Article 3. Thank you.
Thank you, Mrs. Kabelka. Zahid?
I think they have an important role, as was laid out also in when they're in the convention, etc. And I think that's a very key role. It provides a lot of balance. I found that there are tensions between business, civil society, and government. It's a multi-stakeholder forum like the IGF. But at the end of the day, those tensions actually lead to something better, something balanced. So anybody saying that someone should not be in the room tends to be a bit of a, I think you're losing out on value. But what specifically can maybe civil society do? I think that the counter to, what is the source of terrorism? The source of terrorism is speech, is recruitment, is convincing somebody's ideology to do something. That's where civil society can get really, really involved, and it can do it better than government. It can do it better than business. It is the only person who can do it properly. And I think, well, I want to be balanced about that, but more in one of the very most effective manners. Creating awareness about what is happening and asking for a call to action. And giving safeguards to those people who fear that if I say something, I may be attacked in my country, I may be a target, things of that nature. And to get the counter-narrative out, and I'll say this about my own country and many other places, most people who have something to say against something that extremist views are sort of trying to propagate are scared. They also don't know how to be able to do it. They also don't know what's the argument, what's the mechanism, am I a good enough lawyer to try and catch that guy in what he's saying so I can show to everybody on Twitter, for instance, that he doesn't know what he's talking about. These are skills which I think are important, and an encouragement to these people to talk out and some sort of safety. This is where civil society, I think, can play an important key role.
Thank you very much, Sahid, Mrs. Kabelka, for the questions. I will take a question over here on the right. We have a remote question, if I believe. I'll take a question by Gabrielle, and if I may then, one last question over there. If I may then quickly abuse slightly my power as a moderator, we do have 2 more presentations to go. Just to remind you, we will have a presentation on the Budapest Convention, which you already see on your screen. So there will be other things which will feed into this discussion. And speaking about counter-narrative, we will also have an interesting presentation on various approaches on that. So I will take the 4 questions specified, and after that we'll proceed to the rest of the presentations. If you could kindly keep the rest of your questions till after we're done with the presentations, we will take them then. Thank you so much. Over to you.
Does that work? Yeah, okay. My name is Curtis Lindqvist. I work for NetNode, and I had the opportunity to actually be in Estonia with Estonian CERT during attacks in Tallinn and Estonia, so I actually know a little bit about them. I think that the source of the attacks is actually less interesting in this context than actually the results of the attacks. And I think that we have to realize a little bit more to the fact that it can be a citizen sitting. We're all here because we think that the internet has huge potential and that internet is the future for the governments to communicate with the citizens, right? And there's start being a much more important role in society in general for communication from government to citizens and between citizens. And in the context of terrorism, what we think is an act of terror in the real world. So to take an example, the government's way to communicate to citizens in normal cases is to use a radio or TV. If you blew up radio and TV masts, that's a sit-in, or is that a terrorist act? It's even worse on the internet because you can't do this without collateral damage. You'll go do DDoS your government sites, you'll take out a lot of other sites, commercials, you'll affect the operators. It's huge societal impact. I think that this is not a question of the internet or not the internet. It's the consequences that are important. The tools is just a means. What's the impact on society? That's what matters. And I think that's a really important thing to keep in mind here, that what you destroy is the important thing, not the results. That's what it means.
Thank you very much. I will take the remote question now, if I may do so.
There is a question from Mr. Rudy Van Sneek. He's participating in the Clean IT project in Belgium, which is an EU project taking the cyber terrorism. Mr. Wansnick would like to know how to calm down the internet users who are afraid of having limited access due to the procedures we try to implement to tackle cyber terrorism. Many organizations use the freedom of speech to counter the procedures of takedown, for instance. That was the question.
Thank you. Alexander Zeger will be able to take this.
I'm not sure I fully understood it, but I don't think anybody should be calmed down who has concerns. I think concerns should be raised, and we need this checks and balances and criticism, I think, and should take it in a constructive way. But now maybe I didn't fully get the question.
If we do get a follow-up to that question, sorry. We have Gabriele Kimin from Article 19 next. If we do get a follow-up, you can keep it for afterwards.
Hi. A couple of weeks ago, there was a report by the UN, one of the UN agencies, about the internet and terrorism. And I was wondering, like, one of the issues that was touched on in the report was about the role of intermediaries and voluntary cooperation. So I was wondering what were the views of the panel on the role of intermediaries and voluntary cooperation, and also what sort of legal framework they would see in relation to that cooperation. Thank you.
Zahid, please.
That's a tough one. In many other cases, it's something that it's easier to answer. I'll be honest with you. But when it comes to terrorism, that's a pretty tough cookie, like you said. Absolutely, these are tough cookie questions, but they have to be dealt with. Some people point you to the OECD guidelines on intermediate liability. That's one way to go. But terrorism is pretty sort of hardcore crime. I think the liability should not exist with respect to intermediaries who are hosting it as a general commercial purpose. If you are doing this specifically to enable that kind of discussion and speech, then you are aiding and abetting in a positive fashion. So for instance, if you set up a network, and I can tell you these exist, for the terrorists to have secure communication, and that's really the intent of what you're trying to do, then I think that then you lose that cover, you lose that immunity. But if somebody's using Facebook or Google or posting stuff on YouTube, I think to say that the intermediary is liable because that content exists on their website, and therefore they should be subject to cyber... Did you have a clarification or something? Sorry, go ahead.
I think there may be two aspects to this, because
Okay.
one is in relation to the content and intermediary liability. In that respect, what I was wondering about is sort of sharing of information,
Right,
data.
disclosure.
Users. Yeah.
Right, yeah, okay. Even more difficult. I'll be honest. I think the response to that is if you're getting an order from a court, etc., or a subpoena or a warrant, I think you should disclose. You have to. To say anything other just is not realistic, and it won't work. We may not want it, but it won't work. And what we did so in our national legislation was say any other power other than a request for preservation has to go to a judge, and the judge has to order it. So there's independent oversight and there's transparency as to what you're trying to do. So even if it is a real-time collection, if it is, say, for instance, asking an ISP to disclose certain traffic data or content data, well, that would be real-time. Then you would want to have a judicial supervision. And that's, by the way, something that Article 15 of the Convention on Cybercrime requires. Thank you.
Thank you very much, Zahid. I would take one final question. If I could ask you to be quite brief, if I could ask you, I'm sorry, to keep the rest of the questions for after the two presentations we still have, because we have half an hour to go, just anxious that we get as much information in as possible. I'll take your question if I could ask you to be brief about it. Thank you very much.
Hi, my name is Ruben Bloemgarten. I'm with the Chokepoint Project. I was wondering, is there any demonstrable evidence that these anti-cyber terrorism measures have had any impact on the actual occurrences of terrorist activities? Or are we mostly speaking academic?
I think Zahid or Alexander. Zahid, go ahead.
Did you mean the measures based? I'm sorry, I wasn't listening clearly. But what kind of measures? All the measures that we just talked about.
All the measures that you've just discussed. Yes.
So counter narrative does work. for the society that I just mentioned. That's not a legal provision. I understand, number one. Number two, a lot of the measures that we're talking about using provisions to say don't incite, don't have stuff on the media. Where I come from, I can tell you that makes a big difference. I'll give you an example. Two things happened. One, there was counter-narrative on the radio and FM in the northern parts of my country that made an impact. And the second was that there were people actually then able to get out and talk on the media against something that maybe fanatics were talking about. And the third was that criminalizing people, or threatening them at least, did sort of chill the speech a bit. Unfortunately, in my country, I haven't still seen a prosecution that has gone the full length with respect to something like that, even though the provision exists in the law. And that may be more about where I come from and not about other places. It sounds like you have a follow-up.
Yeah, what you're saying seems to me sounds like it speaks to the quality of public discourse.
Right.
And I'm having a hard time understanding how this is actually related to terrorist activity of any kind.
Okay.
So I mean, I understand the quality of.
So I'll explain. For instance, one of the things that in what we've seen as what terrorists do is they recruit. The recruiting exercise takes place when you try to put stuff out there and people are attracted by it. Then you get the tensions really high up. So for instance, you'll start a topic about the fact that the Ahmadis don't think that the Prophet was the last prophet. You start with that discussion. And then you have a whole bunch of people come in. Somebody who doesn't know his religion very well will say, oh, this is absolutely wrong, etc., and this, that, the other. And then they start saying they're targeting those individuals and find out who they are and invite them to other forums. And those are the sort of things that take place. So it's you're trying to get to the root of this and trying to stop recruitment and then training of these folks, for instance.
Thank you very much, Saeed. I think I will take this opportunity now to ask you kindly to keep your questions coming, but just we will have two more presentations. Mr. Alexander Zeger will be the next presentation. He is the secretary to the Cybercrime Convention Committee at the Council of Europe and a renowned expert on the issues of cybercrime, who will now elaborate on this in greater detail. And I will pass the floor to Alexander. I have a PowerPoint as well, so you can see it on some of the screen.
Thank you for the flowers. And from what I understand from interaction with law enforcement, from other agencies dealing with terrorist issues, fortunately, terrorist acts are prevented all the time. They are not made public because otherwise people may panic much more than they actually do. But
are they
can you come
prevented?
later on?
Yeah, are they prevented?
Somebody take the microphone away from me.
Are they? Are they prevented more with these measures in place than they were before? I'm just seriously having a hard time understanding how that would happen. But
I mean, the Council of Europe doesn't just go out and draft treaties if there is no justification for that, because it's very difficult. It's extremely difficult to get criminal law treaties through the member states. It's very, very difficult. It takes many years. The Budapest Convention took 16 years before it was open for signature in 2001. There must be a good reason if we do that. The landscape of what is out there in responses internationally was analyzed in quite some detail, and then a gap was identified when it came to these preventive measures, and therefore the convention that is Madame Kabelka's baby in a way targeted very specific issues that were not covered under others, and they're very useful. Okay, I will now give you a very quick run through the links between the Budapest Convention on Cybercrime and the Convention for the Prevention of Terrorism, and how that covers the issue of terrorist use of the internet. You could summarize what it means, terrorist use of the internet, in 3 points. The one thing is possible attacks via internet or via information technologies on critical information infrastructure or other infrastructure, including loss of life. That's one type of attack. There's academic debate whether that ever happened so far, but the potential is there. The second thing is the dissemination of illegal contents, including threats of cyber attacks, incitements, terrorism, recruitment, training. These are the things covered under the Treaty for the Prevention of Terrorism. And then the use of information technologies by terrorists for logistical purposes, channeling money, gathering intelligence, analyzing targets, and so on. So these, in a way, are the 3 main areas of terrorist use of the internet. And I personally also don't like cyber terrorism, but terrorist use of the internet is maybe an acceptable term. The objective of the Council of Europe is to promote democracy, rule of law, human rights. We all know that. If we take measures against cybercrime or against terrorism or against any other form of crime, it is in order to promote these objectives, because let's face it, a terrorist attack is an attack against the rights of people. The way we do it on the cybercrime side is we are setting, on the one hand, standards, common standards like the Budapest Convention, and they go beyond Europe because we also have United States, Japan, parties to the treaty, and others are coming up. We have the Cybercrime Convention Committee that is assessing now the implementation of how parties implement the Budapest Convention, and then we have capacity building programs to help countries draft legislation, train law enforcement, train judges, engage in public-private cooperation, etc. So this is the triangular approach. But when you, it sounds straightforward, but when you look at what is the structure of the internet, it's fairly complicated. If you look at the structure of cybercrime, it's equally complicated. And if you look at the structure of measures against cybercrime, you have to have a complex response that covers many things, not just a small triangle as I just described, and that's also what we're trying in the Council of Europe. For example, we have the Budapest Convention, cooperation programs on cybercrime, Cybercrime Convention Committee. 2 years ago, we linked it up with our work on money laundering and prepared a typology study with some recommendations. Now we follow up on that, on criminal money flows on the internet. And similarly, we can link up the Budapest Convention on cybercrime and whatever's built around that with our work on terrorism. So in a way, we have this very dynamic, flexible approach to respond to threats in a flexible manner. In a dynamic manner also. Budapest Convention now has 37 parties. Japan recently also became a party. The United States has been a party for the past 6 years. And at any time now, every day now, not every day, but every week, every month, we get additional requests for accession. So very soon we will see many other countries from different parts of the world join the Budapest Convention. And a large number of countries have used it as a guideline for domestic legislation, including Pakistan, that yesterday had a hearing in the parliament of their new cybercrime law. And Zahid, who had to leave, was one of the key drafters of that. Budapest Convention covers, on the one hand, the criminalization of conduct. It requires country to criminalize certain conduct. That includes things like system interference. A denial of service attack, a botnet attack, is system interference. It's covered, for example, there. Data interference is there, and also some offenses committed by means of computer systems are covered there. Terrorism is not listed there, okay? But there's no need, and I'll explain why. Because when you look at the procedural law measures, search, seizure, interception, and so on, they apply to any electronic evidence related to any crime in a country. Not just the offenses listed in the first part of the convention, the attacks against and by means systems. If you have a terrorism case, you need to gather electronic evidence, like in the Pearl case in Pakistan. You can use the procedural measures of the Budapest Convention because there's electronic evidence related to hostage taking on a computer system. So that makes it very broad, and the same applies to the international cooperation provision. The Convention on the Prevention of Terrorism. Thank you. I was now has, as Madame Kabelka said, 29 ratifications, 15 signatures, but it's also open to third countries. And there we have a number of provisions, including the 3 core provisions on Article 5, incitement, Article 6, recruitment, and Article 7, training. We believe, and not just we, the Council of Europe and the Member States believe, because they discussed this in quite some detail some years ago, believe that the Budapest Convention, in conjunction with the Convention on the Prevention of Terrorism, cover almost all the issues. And the issues it does not cover, you wouldn't find agreement on. I think that summarizes a bit debate. So that's my first conclusion. The second conclusion I would like to convey here is the link to rule of law and human rights safeguards. And this message is very interesting, actually, if you read those guidelines, because they would relate to many other areas as well, not just to terrorism. Many of those points would apply also to issues that would be covered under national security and other matters. And one of the themes this week has been, where does criminal justice stop? Criminal justice, where you have all those rule of law safeguards, and where national security starts, where many of these safeguards seem to disappear. And I think these guidelines provide also answers to that. So under those guidelines, it's clear states have the positive obligation to protect everyone against terrorism. And actually, when you look at the case law of the European Court of Human Rights, they also say governments have the positive obligation to protect their people against cybercrime. It is prohibited to be arbitrary. Rule of law safeguards must apply. There cannot be discrimination. Rule of law principles apply. And there must be, any measure you take must be subject to supervision, etc. So there's no exception in the terrorism area here. The same, that any measure against terrorism must be lawful. They must be based on law, and they must be proportionate to the aim pursued. And they must be necessary. So the key rule of law principles also apply when it comes to terrorism. And then there is a guideline, and one of the guidelines is on collection and processing of personal data. Again, must be based on law, must be proportionate, etc. All these things that apply in other criminal areas also apply when it comes to the prevention of terrorism. And again, measures which interfere with privacy. And then possible derogations, there are some, if you talk about war situations, public emergency situations. But the key guarantees, guarantee of the right to life, prohibition of torture, prohibition of inhuman or degrading treatment, and so on, prohibition, the principle of legality, and so on, or the prohibition of making to have retrospective effect of law. All of these principles must apply. You cannot derogate from those. The way ahead, we see it, is to roll out the Budapest Convention on Cybercrime to an increasing number of countries around the world, to provide technical assistance for capacity building, to support implementation of the Convention for the prevention of terrorism, and to reconcile security and human rights concerns and establish safeguards. But again, there are a number of other issues we will continue to discuss over the next few IGFs, at least, when it comes to blocking, filtering, takedown, and what procedures to follow, intermediary liability, and all these things that have been discussed. Thank you.
Thank you very much, Alexander, for this excellent elaboration on the cybercrime mechanisms of the Council of Europe that are applicable, especially in conjunction with what was outlined about the Prevention Convention. I will gladly take questions on this if you have any. Just before we do that, I will quickly turn your attention to, we've talked about the importance of counter-narrative. Certain questions came in this respect. I would like to, our next and final presenter is Ms. Sarah Logan from the Australian National University, who will outline to you the counter-narrative online approaches to countering terrorism that exist. Please, Sarah, you have the floor.
Thanks very much, Anna, and I'll be quick because I know we're running out of time. The presentations so far have focused on legal responses to terrorism on the internet. What I'll be focusing on instead is the softer, more kind of productive approaches. There are things that the legal approaches can't touch. These generally revolve around questions of incitement and intent. I think those issues have been raised already. When I say can't touch, obviously the discussions can be had, but it's a grey area, and these issues, I think, are an alternative way of trying to address intent and incitement. And they also go to some of the points that Mr. Jamil raised about the strength of counter-narratives in combating terrorism online. There are an abundance, as I said, of legal and coercive measures that governments have engaged in to try and combat terrorist use of the internet. Things like censorship, data retention, attempts to engage ISPs in efforts to manage terrorist material online. These policies are unlikely to fade away, but they're potentially problematic for several reasons. First and most fundamentally, they can on occasion conflict or appear to conflict with important values of liberty and freedom of expression, as the controversy over the EC-funded Clean IT project earlier this year arguably showed. Secondly, censorship measures in particular are almost impossible to maintain given the rapid proliferation of terrorist content online. And apart from this, studies have shown that censorship of this sort can in fact be counterproductive in combating radicalisation. So I'm looking at alternatives that governments have to these measures. So the first of the policies I'll be speaking about is the United Kingdom's policy. This policy is run out of the Research Information and Communications Unit established in 2007 within the Home Office. It's interesting because it's entirely covert. Unlike other policies I'll be looking at, there's not much known about what Riku actually does. It's not an open organisation, and what we do know comes from leaks and interviews that people are lucky enough to get. And also, it's interesting because it focuses not only on combating terrorist narratives online, but on controlling the way in which the UK government comments and communicates about terrorist issues. And I think this is largely because this program is part of a larger preventative program aimed at countering homegrown extremism within the UK, as well as extremism online overseas. Riku focuses on crisis response. That means that's an important term to define, I think. I'll do it quickly. It means formulating media templates that can be used when crises occur. For example, like the accidental burning of Qurans by US troops in Afghanistan earlier this year. In this situation, a crisis response would have already been sort of formulated, and when this event occurred, the government was able to put into place mechanisms of communicating messages to trusted partners and ways of devising those messages so that they would be most effective. Riku also spends a lot of time and money researching media consumption habits of populations at risk of radicalisation. I'm not sure if you can see it, but this is a map of Riku, and at least half of Riku is devoted to that sort of research, as far as I can tell. There's also, allegedly populating of forums and news content and so on, but again, it's covert, so we don't really know. The United States is really interesting. They've come to this party a little bit later. The Bush administration did start some measures of this sort. They had a very small digital outreach team from about 2007. But this whole sort of online approach has been upgraded quite recently. The Centre for Strategic Counterterrorism Communications was established in September 2010. It's recently been upgraded. One of the key features of this is that it's an interagency approach housed within the State Department. And it took an executive order from the White House to establish this strong interagency approach. The CSCC is also interesting because it's overt. Everything they do is badged as being from the State Department. So they engage in debate on Islamist forums, badged as the State Department. They also engage in what I would call proactive hacking, and are quite open about it. There's an example there that I've put up on the PowerPoint. In May this year, the Centre swapped Al-Qaeda ads on Yemeni websites. These ads were bragging about killing Americans, and the Centre sort of broke into these websites and replaced those ads with ones showing the deadly impact of Al-Qaeda tactics on Yemenis themselves. And Hillary Clinton gave a press conference about this. They also do crisis response, and they also, interestingly, a bit like what I imagine Riku does, is provide tailored advice to specific diplomatic posts, for example in Somalia and Pakistan, about how to handle certain media situations that may arise, which trusted partners to engage with, and how to formulate a message delivered online that will have an impact. They also produce YouTube videos, and it's if you can Google it, I would recommend it. I have some to show you, but in the interest of time, I'll leave it. But it's fascinating. There's sort of very well produced, very well targeted videos aimed at a very particular segment of the YouTube audience. Saudi Arabia has an overt program as well as covert programs. This one is interesting because it's entirely to do with theological debate delivered online by an NGO funded by the Ministry of Islamic Affairs, using Islamic scholars but also volunteers. The Saudis claim it's quite effective, but it's, as people have pointed out, it's incredibly difficult to manage to assess this, and we have, it's important to be a little bit sceptical about these claims. Singapore also has a similar sort of online theological debate initiative, but it's much more offline than online. It sort of spills into the online arena. But it's a little bit similar to the Saudi Arabian one in that it engages religious scholars in theological debate online as a counter-radicalisation initiative. The United Nations does a little bit of this. It's more in the sort of formative stages. But there was a meeting in Riyadh in early 2011 which was specifically about building online counter-narratives, sharing strategies and sharing resources. Nothing much, as far as I can tell, has progressed from there, but I think that was a very important step. And just intriguing that people think that is a useful multilateral kind of initiative. I'm not quite sure what the EU or the EC are doing in this area. As far as I can tell, most European initiatives focus on, most European-wide initiatives focus on best practice sharing and kind of dialogue between practitioners. But I'd be interested to hear if there is anything more concrete taking place. Now, challenges for counter-narratives are important to go into, I think. It's a new developing area, particularly online. The first is metrics. It's impossible, as I said, to measure, at least overtly, how effective these counter-narratives are, or indeed if they're effective at all. But given the amount of money being pumped into these, I would suggest that someone somewhere knows that they are effective and has some evidence for that. The second challenge is replication across local contexts. A lot of radicalisation draws on local grievances which then feed into global concerns. And replicating narratives, as some of the UN initiatives might seek to do, replicating those narratives across different contexts will be very difficult, and replicating, taking account of local concerns will be important to the efficacy. The third is legitimacy. You can see that the Saudi Arabian initiative tries to take account of that by devolving its activities to religious scholars. And the State Department are in discussions about the badging of their initiatives, which is quite striking, I think. They argue for the legitimacy of the State Department kind of badge in providing a very clear, very direct identification of this narrative with US policy. Thank you very much.
Thank you very much, Sarah. I would like to open the floor once again to any. We have several questions already. I'm noting 3 here. I think the lady at the, if you could kindly provide the microphone with the glasses, is just over there was first. I'll take a question from the gentleman here then, and I'll take a question from you. Thank you very much. The lady over there.
Is it on? Oh. Hello. My name is Danielle de Groot. I'm from the Dutch Cyber Police. I just have a small question about the last speaker talking about crisis response. I find that very interesting. Could you tell me a little bit more about if there's a role in law enforcement, police, in this kind of situation, and what would that role be?
I think it depends on the particular jurisdiction. So from what I know of the US crisis response initiatives, they're not necessarily about pushing those narrative responses to events out through law enforcement authorities because of the legitimacy problem that I mentioned. So what they're trying to do is engage community leaders, people with authority within particular communities, to negotiate the message itself and then deliver it if they agree that it is a useful kind of process. I'm sure in some of those jurisdictions law enforcement is engaged, but as far as I can tell, it's not a precondition.
Alexander, do you have something? No, okay. We have microphone management. I think the microphone's been passed on. Thank you very much, Sarah. And next question.
Someone want to respond, or can I ask a question? Huh? Okay. Come to your.
Could you introduce yourself? I'm sorry.
It's on, yes. To come to your presentation first again, sir. Oh, yes, of course. Sorry, I'm talking so much during this conference that I forget. My name is Wouter Natris, and I'm from the Netherlands also, and at this moment private consultant. I want to take you back as an example to the last presentation to the 1970s in the Netherlands, pre-internet. But we had hostages of trains and schools by a minority from the Indonesian archipelago that wanted to go back to their country and have some promises that were made in the 40s that never came true. But what they actually, the Dutch government did is take the youth, so the second generation, several of them back to where they lived. And what happened a month later, it was a poem in a Dutch national newspaper saying that how beautiful the country was, but we couldn't play our record players, we didn't have any phones, we didn't have any electricity, so what's the use of going to live there when we have to give all that up? In other words, that was the last hostage done by the second generation youths of the South Moluccans in the Netherlands, because they knew that the difference of going back was so much different where they lived. So as an example of what they're trying to do now through the internet, which actually worked in the Netherlands in the 1970s in the offline world. So that is one as an example that something like that can actually have success and work. The second, let's throw the bone into the room, which I usually do. I heard the word clean IT project being mentioned. How does the new idea on terrorism hold itself against governments that are actually proposing measures at this moment which may not be really within the law? So counter-hacking proposals towards government, towards legislative bodies, the Clean IT project, which may be proposing things which as citizens we don't really want to be a subject to. And the same for FISA, of course, which happens in the US.
Question, I guess. Anybody on the panel want to take this, or Alexander?
Well, as I said before, when you look at the guidelines for on human rights and terrorism, it's clear that whatever government does has to be based on law, and there cannot be an exception to that. You may find cooperative arrangements in a way, but in principle it has to be based on law, and that's what we are working on. Also under the Budapest Convention on Cybercrime, we are currently thinking about transport access to data, to clarify that, maybe to work on protocols. We have to see how that works, but again, it's more to put clearer rules there, because many governments may do many things already, and the idea is to put clearer rules, including safeguards, in place. So I don't think Council of Europe would support anything that would be interfering with rights that would not be based on law.
Thank you very much, Alexander. Absolutely agree with your point. I will just take a question over here. If you have any further questions, can you please put up your hand so I can count? If not, then that's great, because we're about to run out of time. So I'll take your question. Thank you very much.
Thank you. It's more a comment than a question, if I may. Yeah, and actually, it relates to the 2 rounds of presentation, and it was a great idea to have in a single panel the presentation of both conventions, because I think we can see in the making, I would say, how threatening are the trends that we can identify. First trend is, in my opinion, the extension of the notion of the concept of terrorism. We know that terrorism is a very serious crime. Cyber terrorism, as my colleague Ian Brown is not well defined, but we know what is terrorism. But now we are assimilating, and this is what I've heard, especially in the last, not the last, but the last but one presentation by Alexander. We are identifying crimes and terrorism. There is a large range of crimes, and the seriousness it depends also of the crime. The Convention on Cybercrime identify offenses like, and they include in the offenses the infraction to intellectual property, for instance. Can we say that, can we seriously say that infraction to intellectual property is a terrorist crime? And can we seriously say that we should apply the same measures and the same provision to this kind of crime? So this is one trend that we can see, the extension of the notion of terrorism. And the second trend is the fact that we are rather identifying patterns of intent with new offenses that are being created, like the one in the Convention on Terrorism, the possible perpetration of terrorist crime. This is the intent. The act has not been committed yet. So we are we are not in a law enforcement context, but we are in an intelligence context, and the issue is to identify patterns. So while I can understand the legitimacy of trying to prevent terrorist acts, when we use the same provisions and the same kind of measures to prevent other kind of crimes, which are less serious, though still being crimes, but less serious than terrorist acts, then there is a concern for human rights and due process of law is here. And the consequence of this need to identify patterns is that we have now legislation on data retention and on systematic monitoring of large groups of people without having any kind of without them being groups of terrorists or groups of non-people that should be monitored. So we try to identify patterns, and these are the two main concerns that I see with these trends.
Sorry, could you just introduce yourself before, just so we know?
Oh, I'm so sorry. I'm Mary Mazuki from the European Digital Rights Association.
Fantastic.
Sorry again.
Thank you. That's great. So on behalf of the European Association, that's great to have that comment. Unless we have to, Alexander, would you like to have a response to this?
I know Miriam is a strong supporter of the Budapest Convention. But just to make it clear, if you write that I said that all offenses in the Budapest Convention are acts of terrorism, then, and the Council will be saying this, then I'm once again misinterpreted. On the, what we are saying is that if you take the Convention on the Prevention of Terrorism, and if you combine with the Budapest Convention, you may be able, or you will be able to address the threats of the terrorist use of the internet. It doesn't mean that Article 9, child pornography of the Budapest Convention now suddenly becomes terrorism, or Article 10 on IPR offenses, on a commercial scale, by the way, it's limited to that in the Budapest Convention, it's really to organized crime, is an act of terrorism. We are saying that the procedural law tools of the Convention on Cybercrime and the international cooperation provisions of the Convention on Cybercrime you can use to secure electronic evidence in relation to any crime, including terrorist use of the internet, and the specific provisions of Articles 4 and 5 on data and system interference may be also useful in case terrorists may attack information infrastructure. And intent, by the way, intent is one of the things, one of the features of crime. And if you have a crime, you need to have intent. And one more thing, if Anshan, which I'm sure he will never do, if I know as a police officer he's trying to kill her, I have to prevent him from doing that. So I need to have a legal possibility to prevent him from doing things, but which, of course, he will never do.
Did you have a comment?
Just want to clarify, to avoid any misunderstanding, that what I was referring to is what you said about the procedural measures that could be used for a general group of crimes. That's it. Yeah.
Absolutely. Thank you.
Anjan Bose from ECPAT International. I think there's a very clear analogy I can draw between what's been said by Alexander just now about the possibility of harming someone. We have in the Lanzarote Convention as well that criminalizes grooming of children for the purpose of having sexually exploiting them. So just the intent is enough. If it can prove that there is intent, then it's criminalized in certain countries. Not all countries have, they have reservations though. But I'm just trying to draw an analogy between what's just said and what's being included in the Lanzarote Convention. Thank you.
Mrs. Kabelka?
Well, I'd also like to add just a few words to what you said. Admittedly, of course, the scope of criminal provisions is broadened by Article 5, to which you referred of the Prevention Convention. The mere preparatory acts, that's true. But that does not mean that the scope of terrorist offenses is broadened, because the convention as such does not define terrorist offenses. It refers clearly to existing law in Article 1 plus appendix. It's just terrorist offenses are those covered by the existing universal conventions against terrorism, such as financing, such as bombing, such as nuclear terrorism, you see? So they are the terrorist offenses we are talking about. No new terrorist offenses are introduced, not at all. The only thing that's introduced is acts preparatory to these existing crimes, you see? And again, I mean, I must admit what you said. If you know that something might be done or might happen, a terrible crime, then of course you should have tools to prevent that, in particular when it comes to terrorist crimes. So I think I'd just like to say that to avoid misunderstandings in as far as the Prevention Convention is concerned. Thank you.
Thank you very much. Mrs. Kabelka, I would like to then quickly draw us to a close because Alexander is also putting his coat on, is about to leave, and I wouldn't want him to miss out. If you could give a round of applause to our speakers, also Zahid, who's no longer absent, for their contributions. Thank you for coming. We've heard some, I hope it was interesting. We've heard some things today about the necessity to address this issue further, I think, and I hope we might be able to do so during future meetings of the IGF. You can always refer to the Council of Europe website or come to me now at the end of this forum if you'd like any further contact or information. Thank you so much for coming.